Hi, everybody. We are live. Elizabeth Mathern from Stern Law. So happy to be with you today. I'm going to give an opportunity for people to join. It is 7 o'clock on a Wednesday. So where am I? I'm here with you on Facebook Live and Instagram and I think LinkedIn. So hopefully we'll have some people join. What I plan to talk to you guys about today, of course, answering your questions live. I'm always available to do that on the Facebook Live sessions. But one thing that I really want to talk to you about today is an application called Cancellation of Removal, VAWA cancellation. So we also call it special cancellation. It's an application in front of an immigration judge. Most people have heard of VAWA, or many people have heard of VAWA, right? VAWA is the Violence Against Women Act. It's a self-petition, an amazing petition that offers lots of opportunity to self-petition for a green card and adjust your status without having to leave the United States to consular process. You also can use it to consular process. No. Okay. That's a U visa I was thinking of. An amazing application. It has a lot of waivers. If somebody has permanent bar, they have multiple entries and exits. We usually look at VAWA, as well as sometimes a false claim to citizenship, potentially. We look at VAWA. But there's another application that many people forget about. Many people forget about. And it fits in with what I do. So we do file a lot of immigration applications, meaning we file applications to USCIS. There's a paperwork packet. You send it in, you get an interview. Sometimes you don't get an interview. Sometimes the interview is waived because you presented such a strong application packet or everything lines up with what immigration knows about you. And then there's also immigration court cases, right? So that's where somebody's been put in removal proceedings, where the immigration prosecutors are trying to deport you. They put you in immigration proceedings, start an immigration case, open an immigration case that can result in you being given the opportunity to stay here, by maybe the case being dismissed, given an opportunity to stay here with status because an application is granted that gives you some sort of a benefit like a work permit or a green card, or it can result in your removal order or voluntary departure, which is also an application. So a lot of people have heard about VAWA, which is not an immigration court application necessarily. And a lot of people have heard about cancellation of removal. Some people call it like 10-year cancellation. Some people call it 42B. A lot of people know cancellation of removal requires you to have 10 years in the United States. Everybody, the 10-year cancellation. So, but it's 10 years. Continuous presence. Qualifying relatives, maybe a parent, spouse, or child, U.S. citizen, or lawful permanent resident. That you have a good moral character, and that those qualifying relatives would suffer an exceptional and extremely unusual hardship. That's a high burden to prove. Also, the good moral character element, many people are cut off because of convictions. So if you have certain number of DUIs, there's a rebuttable presumption that you're not eligible for cancellation because you won't be able to show good moral character. You've had so many DUIs, things like that. And it has some challenges. On the exact same form is an application called special cancellation, which is related to VAWA, the VAWA statute, Violence Against Women Act, but it is not only for women. Okay. In a minute, we'll talk about I I'm going to give you all the information that I know, as much as I can in 30 minutes, which I don't think it'll all fit in here, but let's try to give you the best overview that we can. We're going to talk about who count as qualifying relatives for VAWA cancellation, what battery or extreme cruelty means, the extreme hardship requirement, the continuous physical presence requirement, and bars and waivers. I don't know if we'll be able to cover all that in 25 minutes, and we'll see what kind of questions we get, but please feel free. We're going to jump in just a second, but please feel free to like, share, give us the thumbs up, the bubbles, etc. Get people to join and ask questions. If you see this, later after it's not live anymore and it's helpful to you, please, please make sure to share it and click the little button so you get alerted when I go live, because I'd love to be able to engage with you and make sure that as I'm explaining things, I'm also answering your questions, because questions come up, right? You hear certain things and you think that might apply to me. That might apply to me or my family or my loved ones. So one of the biggest differences to me between VAWA cancellation and cancellation of removal is the timing. So the regular cancellation of removal requires you to have 10 years physical presence or a 10-year look back period. VAWA cancellation only requires 3. So somebody who's recently entered the country potentially could not qualify for a cancellation of removal, even though they have a qualifying relative, or there's some sort of entry or exit that cuts time and they don't have the full 10 years of continuous presence, but they have 3. Also, that 3-year look back period relates to the look back period for good moral character. So maybe there's some sort of issues in the past that don't completely bar you from the application, but would present some challenges. Doesn't mean that, we don't need to argue about or present evidence about what those challenges, were and how you've overcome them. But the look back period is shorter. And so the judge doesn't have to look back beyond 3 years. So that's a big difference. So VAWA cancellation of removal. Let's talk about qualifying relationships that count, because it is a little bit unique. So in comparison to regular VAWA requires that you have not been divorced for over 2 years. So there is a hard deadline that you have to file your VAWA, your I-360, after divorce. If you're going to claim extreme cruelty by a U.S. citizen or LPR spouse, you can't have been divorced for more than 2 years. VAWA cancellation does not have that bar. You just have to prove that during the time of the marriage that you did experience the abuse. So that's a big, big door open for a lot of people that's closed with a VAWA application. All right. So let's talk about the different qualifications or qualifying relatives categories. So there's an abused spouse, former spouse, or intended spouse. So it could be the current spouse. It can be the former spouse, like I talked about, where divorce has happened quite some time ago. No bar based on more than 2 years. And then intended spouse. This is another really interesting space for argument. Occasionally, someone, a foreign national, marries someone thinking that the abusive spouse is free to marry and that it's a legitimate marriage. But sometimes that person is already married to someone else, and the subsequent marriage to the foreign national doesn't count under regular VAWA, but under VAWA cancellation, it does. And so it's a really important distinction. So in other words, that you intended to be the spouse, the foreign national that faced extreme cruelty did intend to be the spouse of this person, entered into the relationship in good faith, and was subject to extreme cruelty during the relationship. Also, another category that is really interesting is you can file VAWA cancellation if you were an abused child, son, or daughter. So if you are under 18, you would classify as a child. If you are a son or daughter of an abusive U.S. citizen or LPR spouse, you could be an adult. So sometimes what we would see is that someone is now an adult, placed in removal proceedings, and a VAWA cancellation would be available to them if during their childhood, years prior in the United States, many years prior, right? There's no time bar. They were in the United States and their parent was a green card holder or a U.S. citizen and treated them with extreme cruelty. And that can be take on many different forms, right? We can talk about what qualifies as extreme cruelty, but the son or daughter does not have to still be a child when they file the application. Also, the parent, the abusive parent, does not have to be still a resident or a citizen. Sometimes people lose their status, right, later in life. But if the abuse happened while that person had the status, that should qualify. Also, you can be a parent of a child who was abused by another parent, so to speak, right? So if the abuse that happened, maybe you were not married to the abuser. This is a place where a lot of people miss this link, right? You were not married to the abuser, but maybe the abuser did or didn't abuse, you as the foreign national, but they abused your child. If you are the parent of a child who was abused by a lawful permanent resident or a U.S. citizen parent, and it can be a step parent, then you qualify for VAWA cancellation because you witnessed the abuse of the child. Okay, you are the parent who witnessed the abuse of the child. So lots of layers to that. We can unpack them, and I'm happy to answer any questions about that because it is a little bit confusing. Battery or extreme cruelty. So most people think of VAWA or a humanitarian application that's based on abuse as you have to have been the victim of a physical abuse. A battery is when most people think some sort of physical abuse where there was some sort of scarring or visible harm. Plus, a lot of people think, you have to have reported it to the police and the person has to have been convicted. Those are not requirements. Those are not requirements because the statute says battery or extreme cruelty. Extreme cruelty can come in a lot of forms. It can be purely emotional, psychological, financial abuse, and it rises to the level of extreme cruelty. And the amazing thing about presenting a VAWA cancellation in immigration court is you get to put on testimony. Whereas in a VAWA application that you send off to immigration, you're putting it all in paper. But in a VAWA cancellation case, you're going to court, but you have the ability to tell your story. You have the ability to look the judge in the eye and say, this is what happened to me. That may be a terrifying, idea for someone who's been through some really traumatic experiences. And that's why you have a great advocate by your side. If testifying, to every detail of something isn't what you're ready for, then we work our case in a different way. But also it can be extremely cathartic. It can be it can be empowering, right? To be able to tell your story. It can also be extremely moving for the fact finder, right? Whereas USCIS officer is just reading a VAWA application, In your court case, it's live testimony. You can present witnesses who saw certain things happen. You can testify. We can present all sorts of things, photographs, not really video, that's more complicated, but we can present a whole case and have a trial with your advocate. That's help structure all of that presentation of evidence, help you prepare for it, help you feel comfortable, help you feel ready for talking about what's happened. It's a great opportunity to really move the ball forward and be able to have that day in court. The continuous physical presence, there is an extreme hardship requirement. So extreme hardship can be to the foreign national themselves, or to, it doesn't have to be to a qualifying relative, right? So where in like cancellation of removal, you would need to prove that like your child is sick or something like that. In special cancellation, it can relate to why you yourself need to be able to stay in the United States because of the hardship you would face if you had to leave. And that's where you can kind of bootstrap in, like compile in hardship related to other family members that may be undocumented and things like that. Continuous physical presence, like I said, is 3 years instead of 10, which is a very, very important thing for many people. And then there are some bars to eligibility. So you still have to prove good moral character. There are going to be some things that can potentially be bars to good moral character. And for example, certain convictions. Also, if you were convicted of a domestic violence offense yourself, that could potentially be a bar to VAWA. However, it is very much understood that, from people who know this type of application and understand the cycle of abuse, that many times a person with status has a power disparity over a person without status. And many times the justice system and the police can be used to assert that disparity of power. And so you may have a conviction for domestic violence, but really you were the survivor, you were the victim. But the abuser was better able to speak the language, had better knowledge of the way the justice system works, how to call the police, how to answer questions in a certain way to manipulate the situation so that it looks like they are being abused. And perhaps you even pled guilty to something because that was what you felt like you had to do. The justice system can be designed where, you really sometimes have such a case built up against you that it's in your best interest to enter into a plea. Well, where that would be a strict bar to regular cancellation of removal, there is a potential waiver available for VAWA cancellation, special cancellation. If you can show that the conviction is related to the abuse. So if you could show that the person, sort of manipulated the system and alleged that you were the abuser when really you were the victim, that is something that can be waived, and that bar can be overcome. That door can still be open to that application. So it's an amazing opportunity, regardless of convictions. You can even, it's sort of ripe for argument of what else is related to the abuse, right? Sometimes people are forced to steal through a number of different reasons related to the abuse. I had somebody who was convicted of reentering, who left the country and was convicted of illegal reentry, a federal crime that could have potentially made them ineligible for any applications. But because it was very clearly tied to the abuse that they had to come back in order to reunite with their children, keep their children safe from the abuser, that was waived, and they were granted the relief. So it's a place that we can really, really look into facts and where we can get around certain bars. So some of the things that you have to show to prove VAWA cancellation that we would be working on with you. One of the biggest obstacles I see people, worried about is sometimes some of the simplest stuff, right? How do I prove that my abuser, he, she, whatever variation, is a US citizen or a green card holder? I don't have a copy of their passport or their birth certificate or their green card. They wouldn't let me have any documents like that. And I fled, or I was able to move out, or there's no way I can get my hands on that without it being dangerous. There's a really great way to get around that. And there's like a statute that we can cite. We actually put the burden back on the government and we say, hey, government, I am a victim of abuse and I don't have access to those documents, but you, government, you do have access to those documents and you can find them for me. So you can actually put that in your cover letter and require USCIS to do that level of investigation to find the proof of the US citizenship or lawful permanent resident status. It's a little trick that I know from years and years of practice, and it works very, very well. So that's something you wouldn't have to worry about, right? Also, evidence of the battery. I never reported it to the police. I don't have pictures of my injuries. So what kind of evidence can you show? Well, remember how I was talking about in immigration court, you get to present testimony. Testimony is evidence. It's powerful evidence. Of course, we have to prepare your testimony so that you're able to feel confident in what you're saying and be able to sort of hit the most relevant facts and present them to the court so that they land well. But we help you with all of that. Evidence is testimony. So if you didn't have a single thing handy, you don't have any pictures, nobody saw the abuse, you can't worry that you won't be able to even file that or win that application. It's possible. Of course, the application is strongest with more evidence, but evidence alone doesn't necessarily make you win. It's about the presentation and sort of how it all fits together and how your story's told. And that's sort of where we come in. That's where, why we're advocates, right? Is to help people tell their story and win their application. That's not to say to tell you what to say. It's to help sometimes unpack layers and layers and layers of what happened, and get it to a place where it's easy for a listener to understand. I am also, thinking about what other kind of, here's something, hardship and good moral character. What kind of evidence of hardship or good moral character could you show? That's where you have, you can bring in that maybe you have children or you have parents that you help care for, or you yourself have suffered some trauma related to the abuse and that you wouldn't be able to receive access to treatment in your home country the way you could here. A lot of things like that can potentially be shown for hardship. Good moral character, as we talked about, the look back period is only 3 years. And so what do we look at for good moral character? Number one, we want to see that we don't have any convictions that bar a finding of good moral character. But in VAWA cancellation, we have the potential to waive or get around that bar. And then also, a court would look at, for good moral character, like what sort of positives do you bring to to the country, right? Like what sort of equity, what kind of person are you? Do you, some of the things that some judges look at are, do you pay your taxes? Do you volunteer? Do you go to church? Do you take care of your children as best as you can within your financial means? Do you have meaningful relationships in the world? Do you work if you have the ability to work outside of the home? Things like that. How do you contribute to society, and sort of what kind of a person you are? That people can feel like they're not going to be able to show that, maybe because maybe they think, oh, I haven't done very much, or because of what I was going through, I was really confined with what I could do, and sort of what kind of relationships I could have outside of the home. That's okay. The good thing is that during the pendency of your court case, you can be building that good moral character. So we can sort of help you understand what it is that courts look at, and what you could do to work on that. Okay. All right. So I only have a few more minutes left. Let's see. One important thing that I forgot to mention is if you win your VAWA cancellation case, you're a lawful permanent resident. You're a green card holder. Okay. And you get a path to citizenship. That means you can file for your citizenship if you got your VAWA granted as a spouse of a U.S. citizen, and you still live with that spouse. In 3 years, you could get your citizenship, in theory. Okay. Otherwise, it's 5 years. So you could take an immigration court case being put in immigration proceedings, and you could convert that to a green card because you were able to tell your story and you were able to talk about what's happened to you, and have a judge grant you an application for a green card. It's an amazing, amazing application. And I think that it is something that a lot of attorneys forget about. And I think that I really try to talk about it as much as I possibly can, because I want to empower people to think about it, if it relates to something you've been through. And then in potentially like a consultation, you could say, well, what about this? I might qualify for this. Because sometimes a person may not ask you about abuse, or they may not like talk about abuse in a way that resonates with you, or they just may not feel comfortable asking, or you may not feel comfortable really revealing details. But if you sort of have an understanding of what the application is and how it can help you, then you can be the one to bring it up and ask questions about it. So, and there are lots more information that we can share with you. If you want to do a consultation and be screened for VAWA cancellation, we'd be more than happy to help you with that. These are really wonderful applications, really wonderful opportunities to change your life, to sort of take a bad thing of immigration court and have access to an application that you can't file unless you are in immigration court. So it's actually a really great opportunity to have access to an application that is so expansive and can really be used to get around a lot of bars, get a green card without having to leave the United States, here in the US, from an immigration judge, get a green card, be able to apply for citizenship, and have a completely different trajectory of your life. So my name is Elizabeth Mathern. I've enjoyed spending time with you. I'm so glad that you watched this video about VAWA cancellation of removal. Please feel free to reach out to us. I'm going to pop the phone number on the screen. Let's see. I have it. I may not, folks. Anyway, it's 404-990-4112. That is Stern Law. I'm Elizabeth Mathern. I am the managing attorney here at Stern Law. I oversee the legal strategy. I do some consultations. I work some court cases. I really, really love the work we do, and I think that you'll be really, really happy if you choose us. So please feel free to reach out. Feel free to post any questions or private message us if you're interested in more information about what we've talked about here today. And I hope to see you next week, Wednesday at 7 p.m. Thanks so much, y'all. Take care. Bye-bye.